Welcome to the self-represented Pro Se and Family Court channel. Today we're diving into a critical issue: how judges can discriminate against you as a pro se litigant, or as we like to call them, brave souls who dare to represent themselves in family court. Now you might be thinking, isn't the legal system designed to be fair and impartial? And to that I say, oh bless your naive little heart. Because while the ideal of equal justice is plastered on every courtroom wall in this country, the reality is often far more grim, unfortunately. So, you decided to take over your own divorce or custody case, did you? Thought you could navigate the complex family court system all by yourself, without any repercussions from the court? You showed up ready to make your case for divorce or custody, maybe ruffled a few feathers in the process? Perhaps you believed you were standing up for justice, for your family and kids, making your voice heard? Well, congratulations. You might just find yourself slapped with the scarlet letter of the family court system, the dreaded vexatious litigant label. This isn't just a slap on the wrist, it's a serious mark against you as pro se. Judges can decide that some folks, particularly those who are courageous enough to come to their court unrepresented, filing multiple petitions, numerous motions, and making a range of demands, they can consider you too litigious. They see you as someone who abuses the system, clogging up the courts with what they call typical pro se tactics. Suddenly you're no longer a concerned parent or spouse seeking justice. You're a nuisance, a troublemaker. Your intentions and self-advocating, no matter how noble, are overshadowed by your actions. Another issue with getting financials from the other party, or issues of uncooperative co-parenting, have come up, and you need to file yet another motion? Well, get ready for a mountain of paperwork, because you now need a judge's permission. Every step you take is scrutinized, every document you file is questioned. The path to justice just got a lot steeper. Now let's talk about the fine line between your legal competence and, well, needing a more apt advocate to do the work for you. Judges can decide that your insistence on being pro se is causing the court undue delays, unnecessary appearances, and extra work. They can use this as a basis for insisting that you hire an attorney instead. Determining legal competency should not be a criteria, but it often is for self-representing. All it takes is a judge's subjective opinion, and bam, you're deemed not legally competent enough to represent yourself. Now let's say you're dealing with a family court matter that's more tangled than a headphone cord after a cross-country flight. In these instances, judges love to whip out their complexity card. They'll start throwing around so much legal jargon that your head will spin. And then they'll tell you that this case is just too complex for a simple, unlearned peasant like yourself to handle on your own. But here's the thing. Complexity shouldn't be a barrier to justice either. Let's talk about courtroom decorum, shall we? Judges have the power to revoke your right to represent yourself if they deem your behavior disruptive to the court or the other party. We're talking about things like talking out of turn, interrupting the judge constantly, not answering questions, or even merely insisting that your rights to be pro se be enforced. Judges need to maintain order, but this rule is often used to silence pro se litigants, especially those from marginalized communities who might not be privy to the unspoken rules of courtroom etiquette. Ah, the wonderful world of legal procedure, where a misplaced comma can derail your entire case. Procedural rules supposedly exist to ensure fairness and efficiency, but for pro se litigants, these rules can feel like booby traps. Judges often demand strict compliance, holding pro se litigants to a higher standard in most cases. Lawyers can pull the same exact procedural error and get nothing more than a courteous nudge to correct it. But let a pro se litigant do it, and it's divorce or custody case suicide. Let's talk about the fine art of legal procrastination. Judges have an arsenal of delay tactics that can drag out a case for months, even years. Continuances are the name of the game. These delays might seem like minor inconveniences, but they can have devastating consequences for pro se litigants in divorces or custody cases where things change from second to second. They can lose their jobs, their homes, their health, and most importantly, their families as the case drags on and on. Imagine this. You've spent countless hours researching the relevant laws, crafting the perfect and most solid legal arguments, and drafting a motion so compelling it would make Atticus Finch weep with envy. You proudly march into court, feeling confident, prepared, Like you could take on the entire legal profession and win. And then, bam, your motion gets denied. Judges have a frustrating habit of routinely denying or ignoring motions filed by pro se litigants, often with little to no explanation for doing so. And last, let's talk about the nuclear option in a judge's arsenal, the dreaded contempt of court charge or the threat of being forced to pay the other party attorney's fees or legal fees. While a threat of paying additional fees that are not yours can be a really big deterrent for pro se litigants. A contempt of court charge can land you in jail and scare you enough where you give up your right to pro se at the drop of a dime. Not to mention, the judge can also threaten to dismiss your case entirely if they deem you in contempt. So there you have it, my pro se comrades, a glimpse into the often overlooked world of judicial discrimination against pro se litigants. It's a system rife with challenges, but awareness is the first step toward change. Thanks for watching. If you found this video informative, don't forget to like, share, and subscribe for more content.